Before you book your next flight, before you renew that passport stamp, and before you assume your green card guarantees automatic re-entry into the United States, you need to hear this. The Department of Homeland Security has confirmed major changes affecting green card re-entry, and these changes are set to reshape how lawful permanent residents travel in 2026. This is critical because for the first time in years, re-entry is no longer being treated as a routine formality for every green card holder. DHS has made it clear that re-entry scrutiny is increasing. Certain travel patterns may trigger denial or delays, and in specific situations, re-entry can be halted altogether. If you are a green card holder, planning international travel currently abroad, or even waiting on a pending immigration application, this directly affects you. Today's video is not about panic. It's about clarity, preparation, and protecting your status. So what does a green card re-entry halt actually mean? It does not mean that every green card holder is banned from returning to the United States. It also does not mean that green cards are being canceled overnight. A re-entry halt refers to DHS exercising expanded authority to stop, delay, or deny entry to certain green card holders at ports of entry when specific conditions are met. Under the 2026 rule changes, Customs and Border Protection officers are being given broader discretion to question whether a person has truly maintained permanent residence in the U.S., whether their travel history suggests abandonment of residency, or whether there are unresolved compliance issues in their immigration record. In the past, many permanent residents believed that as long as they had a valid green card and stayed outside the U.S. for less than 6 months, re-entry was almost automatic. That assumption is no longer safe. DHS has confirmed that travel length is only one factor, and in some cases, even shorter trips can raise red flags if combined with other risk indicators. This is why the term re-entry halted is being used. Entry is not guaranteed, and in certain scenarios, it can be stopped pending further review or outright denied. Let's talk about who is most affected by this change. First, permanent residents who are currently abroad. If you are outside the United States and have been staying abroad for extended periods, especially repeatedly, DHS may question whether the U.S. is truly your primary home. For example, someone who spends 8 or 9 months every year outside the U.S., even if each individual trip is under 6 months, could face problems. Officers may ask where you work, where your family lives, where you pay taxes, and where your primary residence is located. If the answers point more strongly to another country than to the U.S., re-entry can be delayed or denied. Second, frequent travelers are at higher risk under the 2026 rules. This includes business travelers, consultants, remote workers, and anyone whose lifestyle involves constant international movement. Even if your trips are short, frequent exits and entries can trigger enhanced screening. DHS has stated that travel patterns suggesting the green card is being used as a convenience rather than as proof of permanent residence may justify stopping re-entry for further investigation. Third, green card holders with pending applications are also affected. If you have a pending naturalization application, a pending I-751 removal of conditions petition, or any other unresolved immigration filing, re-entry scrutiny can increase. In some cases, DHS may pause re-entry until additional documentation is reviewed. This does not automatically mean denial, but it can mean secondary inspection, delays, or being asked to sign documents acknowledging potential abandonment concerns. Now let's address why this rule change is happening. DHS has framed the 2026 changes as part of a broader effort to enforce the legal definition of permanent residence more consistently. A green card is not meant to be a long-term travel visa. It is meant to reflect an intent to live permanently in the United States. DHS has expressed concern that some residents maintain strong ties abroad while keeping only minimal ties to the U.S., which undermines the purpose of permanent residency. Advances in travel data, tax data sharing, and entry-exit tracking have also made it easier for DHS to identify long-term travel patterns that were previously overlooked. Another reason is border and immigration system efficiency. DHS has indicated that increased scrutiny at re-entry helps reduce fraud, resolve status issues earlier, and ensure that immigration benefits are used as intended. While this may sound abstract, The real-world effect is that more green card holders are being questioned, and some are being stopped from re-entering until their status is clarified. It's important to understand what this does not mean. This does not mean DHS is randomly revoking green cards at airports. It does not mean that one international trip will automatically put you at risk. And it does not mean that lawful permanent residents have no rights. Green card holders still have due process protections, and in many cases, re-entry issues can be resolved with proper documentation and preparation. Let's walk through some clear examples. Imagine a green card holder who lives in the US, works full-time, files US taxes, and takes a 3-week vacation abroad once a year. That person is extremely unlikely to face re-entry problems. Now imagine someone who holds a green card but lives primarily abroad, works for a foreign company, and only returns to the US a few weeks a year to maintain the card. Under the 2026 rules, that person is at significant risk of having re-entry halted. Another example is a conditional resident who has a pending I-751 petition. If that person travels abroad without strong proof of U.S. ties and returns close to the expiration of their extension notice, CBP may stop re-entry until the case is reviewed. This does not automatically mean denial, but it can mean stress, delays, and legal complications that could have been avoided. Now, let's talk about possible exceptions. Some green card holders may still be able to travel safely, even under the new rules. Those with approved re-entry permits generally have stronger protection, especially for extended trips. However, even a re-entry permit is not an absolute guarantee if other abandonment indicators are present. Certain humanitarian situations, such as medical emergencies or family crises abroad, may also be considered as mitigating factors, especially if properly documented. Military families, government employees, and individuals temporarily assigned abroad by U.S.-based employers may also have stronger arguments for maintaining permanent residence. The key is documentation and consistency. DHS is looking at the total picture, not just one document or one trip. So, what are the biggest risks green card holders face under the 2026 changes? The first is assuming nothing has changed and traveling unprepared. The second is failing to maintain strong U.S. ties, such as not filing U.S. taxes, not having a U.S. address, or not maintaining employment or family connections in the U.S. The third is traveling while a case is pending without understanding how that case interacts with re-entry rules. Timing also matters. DHS has indicated that enforcement will increase gradually through 2026, not all at once. This means some people may travel without issues early on, while others later face stricter screening. Unfortunately, this inconsistency can create confusion, which is why staying informed is so important. What should green card holders do right now? First, evaluate your travel history honestly. If you spend more time outside the U.S. than inside, that is a warning sign. Second, strengthen your U.S. ties. File taxes as a resident, maintain a U.S. address, keep bank accounts active, and document employment or family connections. Third, consider applying for a re-entry permit if you anticipate extended travel. Fourth, avoid unnecessary international travel if your status is complicated or if you have a pending application. It is also wise to carry documentation when traveling. This can include proof of U.S. employment, recent tax returns, lease agreements, mortgage statements, or letters explaining the purpose of travel. These documents may never be requested, but if they are, having them can make a critical difference. Most importantly, do not rely on outdated advice. Immigration rules evolve, and what was safe 5 years ago may not be safe in 2026. DHS has been clear that permanent residence comes with expectations, and re-entry is no longer a rubber stamp. As we wrap up, here is the bottom line. DHS has confirmed that green card re-entry is changing in 2026, with increased scrutiny and the real possibility of re-entry being halted in certain cases. This does not mean panic. It means preparation. Green card holders who genuinely live in the United States, maintain strong ties, and travel responsibly are still well protected. Problems arise when the green card is treated as a convenience rather than a commitment. If this video helped clarify what is happening and what you should do next, make sure you stay connected. Immigration rules change quickly, and accurate information is your strongest protection. Subscribe to USA Immigration Explorer, turn on notifications, and share this video with anyone who holds a green card or plans to travel internationally. Staying informed today can prevent serious problems tomorrow.